Hey everybody, welcome to another episode of the Olympus Wealth Strategies podcast, where we help you take your finances to great heights. I'm your host, John Sidery, and got a special guest with us here in the studio today, Taylor Stockemer from the Friday Law Firm. He'll give some background on himself, but really excited for especially you business owners and people thinking about acquiring a business. This is a great podcast that hopefully is going to create a lot of value for you all. So Taylor, thanks for joining us.
Appreciate you having me here. Excited to be here, excited to talk about different structures a business can go through and how attorneys can help. We're not always bad guys.
Yeah.
You know, sometimes we get a bad rap, but a lot of us are here to help. I graduated from Arkansas State with an economics and finance degree, got an MBA there, and then attended law school at the University of Arkansas Little Rock Bowen School of Law. I've been practicing mergers and acquisitions and tax law for up to about a decade now.
Well, and kind of theme of some guests on the podcast, Taylor's too humble to share, but football was a big part of your life up through undergrad, right?
Up through undergrad, played football at ASU, had some good teams up there, really helped me develop as a person and as well as a player on the field, get my academics in order. Got the opportunity to go a little bit after undergrad and signed with the Dolphins after that and moved forward with my life into law school after that.
This might be the one and only NFL athlete we have on the show, so special podcast. So maybe talk through, and maybe we'll break it down more and more, but just at a super high level, Taylor, maybe start off with telling us what a merger or acquisition entails and maybe some initial steps people even have to go through thinking about it.
Sure. And, it's not always on everyone's mind when they start a business, they own a business, they run a business, of how can I sell this or can I buy another? And those are two different strategies a business owner can have in their back pocket based on where you want to go. Growth strategy, you buy other businesses. A sellout strategy, maybe towards the end of your career where you're thinking your time is going to be over with in the business world and you want to retire. And
it seems like a lot of business owners, for whether it be small businesses or ones they've built up, a lot of their net worth is tied up in their business, whereas they keep reinvesting it, and this is a way for them to monetize that to enjoy the next phase of life.
Very much so. And on a high level, mergers, acquisitions, buying and selling is essentially, on the sales side, you're relinquishing your control. And what I've noticed throughout my time is that's hard for a lot of people. It's hard when you put the time, the sweat, the tears into developing something, and then you have to hand your baby off to someone else. It's hard to do, but it's also rewarding in many aspects. And various ways you can do that. Typically, you'll see that change of control being a sale of equity interests or the sale of all of your operating assets.
Well, let's just dive straight into that. So maybe talk about the different types of sales when you go through and a business owner comes to you, right? And they're engaging with you and they're asking, maybe they've got some buyers that are interested in it, and you're going through the mechanics of what might be the best structure for the best transaction. And so maybe talk about the different types, whether it's a cash sale or sale of assets or anything else that might be worthy for our listeners to know.
I'm going to try not to get off into too much of a spider web on this, but I do get excited talking about it. There are, like I said, two main ways to do it: the sale of equity interests and the sale of assets, or on the buyer side, purchasing equity interests or purchasing assets. The equity interests tend to be a cleaner route, more or less, because say you own an LLC, say you own a corporation, they are buying those equity interests from you, or you are purchasing someone's equity interests. And so the true transaction or the sale is just the exchange of those shares or units of membership interest in an LLC. With that comes, you're inheriting everything that a previous business owner or a potential seller has done in their career. So if they've had a 30-year-old business, when you buy those units of membership interest, buy those shares, you're inheriting those past 30 years. And that's always something to think about, because there are sometimes hidden liabilities. On the flip side of that, if you were to purchase assets, you were taking their assets, whether it be hard assets, intangible assets, and you're taking it and bringing it to your own entity or corporation, however you structure yourself. And that's oftentimes a hurdle, because you'll have to get consents. There may be conflicting terms and agreements, and you've got to reach out to a lot of third parties to say, hey, is it okay if I do this? Is it okay if I do that? And that's purely based on your industry and the contracts you have within your industry. But if you take the assets, for the most part, assuming you don't take any liability with you, such as a note or any debt, you're getting those assets free and clear, and you don't have to worry about that, say, 30-year history of that business.
Is there one that seems to be more common than the other, or one that maybe can lead, especially for people who are listening that own a business and they might be in this phase of life where they're at least thinking about wanting to monetize their business? Is there one that might lead to a more lucrative outcome, or is it just really very industry and company specific?
I think it's very industry and company specific. You'll have industries or companies that don't have a lot of inventory or a lot of assets that are hard assets. If you look at law firms, doctors' offices, a lot of healthcare related industries, you'll see that the value of the practice is all goodwill. At the law firm I work at, we don't have very many assets that are worth anything to anybody. It's all purely goodwill. Flip that, if you owned an auto parts store or a car dealership, your value is a lot in your assets.
Right. That's a good point. So as far as owners and wanting to sell, and we talked about the different types of transactions that they might end up going through, they probably should prepare years in advance for the sale, correct? It's not just, hey, they wake up one day, I'm ready for a new phase of life and I'm going to sell this business, right? There's probably things they can do along the way to make their company more presentable or potentially more profitable on their exit.
So that is my big ticket. I try and tell people ahead of time, treat it as if you're going to sell it. And what that means is get your financials right. Get your inventory right if you have it. Get your organizational documents correct. Get your HR policies good. Have all of your agreements in a place where you can find them, where you know where they are. Make sure they're executed. Make sure everything is in order, even if you're not selling, because when the buyer comes, or when you're a buyer, you want to see all that information immediately. And that's part of the process when you're selling your business or you're buying a business is once you agree on base terms, you say, all right, I want to see what you have, provide me your diligence. And so if it takes a seller a month to get his contracts here and, we have this, but it wasn't signed, we've got to make sure we sign it, or we've got to start going and finding this or going and finding that, it slows the process down, can lead to some frustration.
Does it ever create any doubt on one party's end?
Oftentimes, yeah.
Yeah.
And sometimes if you see a big private equity firm coming in trying to buy something, they've seen it time and time again. If it's a one-off buyer or a one-off seller, that can create some doubt. And so keeping that diligence, I'll call it the diligence folder, but keeping that diligence folder up to date, even on a yearly basis, semi-annual, however you want to do it, is really beneficial just for housekeeping matters and in the event you decided to sell.
So either way, I guess that's a big takeaway point for business owners is either way, whether you want to do it now or you don't know if you just started your business and you think, hey, I've got 20 years left to grow this thing before I sell it. I don't need to worry about investing the time and keeping my diligence folder up to date, keeping those documents handy. You're going to have to invest that time now or later. So you might as well do it now. And when you get to that point, you can present a very clean diligence folder and say, hey, this is what you needed. Here it is. And, a couple business days as opposed to 2 months later.
Right. And it's always a joy when you work with companies that are prepared and they say, hey, here's exactly everything that you're going to want to know about this business plus more. it's all available right here, and it makes the transaction go easier.
And probably from a valuation standpoint, or maybe a negotiation standpoint between the buyer and seller, hopefully that leads to a better negotiation standpoint as far as valuations or how they want to structure the deal.
Yes, and we've seen oftentimes where the parties will agree upon a value, will sign a letter of intent, they get the diligence, and all of a sudden something comes up maybe a month down the road that wasn't previously disclosed that may change that value. And then you get back to a point of, well, I don't think your business is worth this because of X. There may be regulatory concerns, there may be debt concerns, there may be some sort of consent or permitting process that prohibits, the sale, or some undisclosed liability or potential liability that may drop that value substantially.
So we talked about kind of having your diligence folder, but for a second for the buyer that's listening out there, whether it's acquiring another business or ultimately wanting to just buy into something that's already started and operating, what are some, outside of the diligence folder, what are some main legal or financial factors that they should consider? And certainly when it comes to someone like yourself, what are things that you engage with your clients on well before they execute on purchasing a business?
You want to know everything about it, and specifically on the financials, you'll want to go through financials, you'll want to go through tax returns, and you'll want to, as far back as you're willing to work and review and value that, because like I said, you don't want some sort of undisclosed liability, especially as you said, buying into something. If you were to buy equity interests into a company, there may be some sort of liability out there or some unknown that you weren't aware of, but once you buy in, you become a party to that. Mm-hmm. And I've seen an instance where that's hurt somebody, and it did not have a very positive effect. As far as the legal considerations, they almost go hand in hand with potential financial pitfalls, in that those unknown liabilities, or is this something that one you can do legally, and that can kind of spider web if you get involved, and maybe you have your hands in a couple of other businesses, and now you've bought in somewhere, and technically you're breaching a confidentiality, or you're breaching some sort of non-compete with ownership in a different industry. Those are all big considerations to have.
So obviously due diligence is critical.
Mm-hmm.
Can you maybe walk through, for listeners who have never gone through a legal due diligence? Obviously, books and records sound like almost a number one thing, but anything else that involves due diligence on either side of the aisle, whether it's someone selling or someone buying?
So aside from books and records and contracts and things of that nature, oftentimes people just want to walk the grounds, assuming it's an industry or a company that has a brick and mortar footprint, and there's always some hesitation there, because if you're a business owner and you haven't disclosed to your employees, they may be potentially selling,
there can be some risk there of retention, right?
Right. Yeah. Having some people in there whom you've never seen before walking around starts to raise questions, and once employees catch wind of that, there's always a fear of what happens if my boss is gone. Mm-hmm. Am I going to have a job tomorrow?
And they may start looking, when the business owner is selling this kind of cash flow machine, if you will,
right,
and which is relied upon by the employees that are doing great work for them,
right,
and they don't want that disruption out of anything else that could come up,
right. But also, as a buyer, say you are touring a facility, or you're at a shop, or you're at a company, there may be things that you can discover that you can't see on books and records. The quality of a machine, it may look good on financials, it may not be fully depreciated. You may walk in and that thing may be broken. Yeah, and you were going to spend $20,000 on that, and you look at it, and
the hidden liabilities that you talked about.
Yes. Or, if you're purchasing a company that involves real estate, you could almost tell if there's an environmental issue there, or if there's a zoning issue and things of that nature that may or may not be readily discoverable looking at books and records.
So obviously due diligence is a big theme. Is there a rough time frame that legal due diligence from the moment somebody approaches, let's say one of your clients who owns a business and wants to buy it from them? Is there a time frame that people should expect due diligence to last?
That can somewhat be industry specific, especially if you have to go obtain regulatory consents or you have to, wait on some sort of third party to give a green light. Typically, you'll see somewhere between 60 to 90 days. Oftentimes, it stretches a little bit further than that just because somebody finds something and starts asking questions. They'll receive answers. You'll ask more questions because as a buyer, you want to know absolutely everything there is to know about what you're about to invest in. I mean, similar to that of buying a home, you have your inspector and you're going to walk through and you're going to try and find every little detail just to make sure you're fully aware of what you're about to invest in.
That's a good analogy. And then kind of the back and forth from, touring the home, if you will, kind of buying just a house, versus the inspection and then the back and forth negotiations and just probably on a lot bigger scale at that point.
Yes.
So Taylor, whether you're a buyer or a seller, you talked about some pitfalls that come up. What are maybe some legal pitfalls that you see, whether you're starting early on engaging on a deal or it comes to kind of that 11th hour? What are maybe some legal pitfalls that could kind of, for lack of a better phrase, blow up the deal?
I've seen this way too many times, and it always is a pain. It's not usually a deal killer, but I've seen it kill deals before. Contractual language in contracts that a company currently has executed and is ongoing. You'll see a lot of what they call change in control or sale of assets, and it's usually embedded probably somewhere in the bottom of a contract that you may not even think would be there. And it says something along the lines of, in the event you sell all or substantially all of your assets or change of control, meaning the sale of your equity ownership greater than 50%, so the majority, you'll have to get a consent or the other party has to approve or something of that nature. Now, if it's an industry that has very contract heavy work where maybe your vendors and your suppliers, you really need those relationships, that can be almost a deal killer or a poison pill.
So I would imagine you're probably selling that almost probably like real estate, right? If you have a tenant that has a certain amount of time left on their lease, you're kind of selling that cash flow, known cash flow.
Yep.
And so it sounds like that's the same thing from the business world.
And that is a big one in real estate is oftentimes you'll have tenants that'll have some sort of first right of refusal in an agreement, in a lease agreement, or if it's a real property, there may be somewhere embedded in a deed or in some sort of purchase agreement that the previous owner or somebody else may have a right of first refusal. So if you're the third party buyer and you go ahead and do that and the seller says, oh, it's free and clear, you can do it, that third party has a right. The person who had the right of first refusal may have that right to step in your shoes and take it from you.
Interesting. So it's, really contracts and everything that's in the contract. It sounds like that's kind of the first step for maybe on your end is reviewing all the legal documents and the organizational documents and seeing what's in there as far as if you sell this, what are the implications given the current language?
And I'm glad you mentioned the organizational documents. Those often are very tailored to a certain group of owners. And so let's say you own a corporation, you'll have articles of incorporation, which are filed with the respective Secretary of State. You'll generally have bylaws and maybe a shareholders agreement. And so oftentimes those shareholders agreements will contain language saying you must get 100% of the vote to sell, you must get 75% of the vote. There may be various thresholds there, but that could prohibit a company wanting to sell in the event that there was a shareholder that says, I'm not doing this.
Well, especially if you think about people who are in different phases, right, who might be equity owners for companies out there that have succession plans kind of in place, but maybe haven't looked at their organizational documents, where you might have owners that are of a generation of getting ready to enter into a different phase of life and want to sell and monetize. And you might have a lot of succession plan owners who are in an early stage and think, hey, we don't want to sell because we came here to buy into this and build it and grow it, and then we want to monetize it.
Right. Right. And I've seen that very instance happen, the exact same scenario you just spoke of, where the younger generation of shareholders were doing anything and everything they could to stop a sale. And as a buyer, that's frustrating because, you've foreseen that you've had this opportunity, this potential opportunity to buy, and organizationally they haven't figured it out or come to an agreement on it.
It seems like maybe before you even start to engage with, if you're an owner of a company, you start to engage with people who want to buy your stake or ultimately buy the company, is making sure everybody who has a vote is on the same page and on board before you proceed forward.
Mm-hmm. Definitely. And sometimes that's not an issue. If there's a business with one owner, if there is a business with two owners and they're both in on it, that's fine. When you start to have more and more owners of a business trying to sell either the assets or the equity, it can be somewhat hairy.
A lot of cooks in the kitchen, right?
A lot of cooks in the kitchen. And two, oftentimes now people want, your C-suite people will want some form of equity. And so as an owner or business owner, sometimes people are generous and will give them 1%, 2%. But in the event of a big change of control, oftentimes those people may get the short end of the stick. And, at that point, there can be some disarray in your organization because it's that same question: do I have a job tomorrow? Or are they coming in and buying my 1%, which may not be valued very much, as opposed to having 80%. And then there's a new sheriff in town, and when the buyer buys it, and does that C-suite person still have a job?
And am I from the employee's position, am I going to be treated like an owner, albeit if I even am a minority owner of just a couple percent? Am I going to be treated in that fashion, or am I just going to be going back to being treated as kind of, hey, get back to your desk and you answer to us now?
Yep.
So what are some other maybe tax considerations that come up for someone who's selling the business or even really buying the business? We talked about different types of sales that can go through. Can you maybe talk about, circling back to that point, what that means from a tax side of things, and maybe why one is chosen over the other, and what that can mean to somebody acquiring or selling their business?
So that is a very good question that has a very complex answer.
Okay.
And so I'll hit the highlights of it, not providing any tax or legal advice here, but generally how we see that structured is when you sell your assets, for the most part, you're going to have ordinary income tax payable on that. Mm-hmm. When you sell your stock, or your units of equity, you're going to have capital gains tax on that. So that's always a big consideration, and that I can talk on that for about an hour straight on how we structure deals to be the most tax efficient for our client, whether they be buyer or seller. From a buyer standpoint, you always want to buy the assets just based on how that affects you and how you can book inventory up based on the industry. As a seller, you'll always want to sell your equity because you'll have the capital gains, which is more favorable than ordinary income tax.
But like you said from the get-go, there might be industries where you're a very true hard asset heavy industry, or whether it be in an industry like I operate in or you operate in, very much just outside of our computers and desk in our office, right? There's really not much hard assets there. And so there's really only equity to purchase or sell at that point.
Right.
So maybe since we live in a state especially that really champions entrepreneurs, and, you look around here and there's, while there are some really big names, but those big names have grown, you just look around town, there's a lot of small businesses. And I think what might be helpful for listeners out there is just to understand, is there, because I'm sure you get this question a lot from just, cocktail conversations, and people will secondhand ask me, is there a type of entity that they should structure their business? I know that's a loaded question because it's sometimes industry specific, but when we talk about always building your business with the thought of selling, is there one type of legal organization structure that makes more sense than others?
Sure. Without being industry specific or focusing on certain aspects of growth, the LLC, the limited liability company, is probably what we recommend almost every time. I feel confident in saying that. Just the way they are structured, tax-wise, organizationally wise, through our statutes here, it's easier to navigate. Corporations tend to be a little bit more rigid on a statutory basis with required meetings and this and that and shareholder vote. And there's a wealth of history based on why the statutes are why they are. But limited liabilities provide for a lot more flexibility and a lot more control on an owner basis.
And so when we talked about having clean books and records, not to get too much into the weeds, that's probably a good reason to ensure that, they have the phrase, piercing the corporate veil, right? To make sure that if you're going to have an LLC and you're kind of a solopreneur, having those books and records to ensure that really your liability from your business stops there and doesn't bleed over to your personal.
Sure. And, that the limited liability does protect, except for certain circumstances, which would be piercing the corporate veil, it does protect your personal assets from liabilities of the company. And when we say piercing the corporate veil, it is, I like to phrase it as, you've done something so heinous that you probably should be getting in trouble for it.
Yeah. So it's not just one of those, oh gosh, hey, I accidentally misplaced this or did something. It's you. It sounds like very negligently or maliciously did something.
Maliciously, fraudulently, doing things that are oftentimes against the law, or things that are so frowned upon that, like I said, you should be getting in trouble for, embezzling money, things of that nature.
You mentioned, obviously, there's a lot of moving parts, right? And there's a lot of things that go into buying or selling a business. And outside of somebody like yourself being a mergers and acquisitions specific and tax specific attorney, are there any other team members that seem to play a big role when you sit down at the table?
Yes. And it's always good to have your team with you. And what I mean by team is get your attorney involved very early on. Get your accountant involved first. That is the person who generally knows the financial condition of your company, knows primarily your tax returns as well, and can tell you essentially what you're worth. And oftentimes I've had clients ask me, do you think that's a good price? Well, I can't tell you that, but I know somebody that can.
Yeah.
And so getting your accountants involved, if you have business consultants, if you use brokers, if we get to that stage, get those people involved and have everybody at the round table when you're making these high-level decisions or discussions, and get everybody's input to have a cleaner approach to move forward.
So kind of some imparting wisdom, if you can share that with us. You've given our listeners a lot of good insights. For the first time buyer or seller, what are maybe some high-level things that you would want to leave them with to say, hey, this is really what you should be thinking about if you're thinking of selling or buying a business for the first time?
So I'll touch on selling first. First thing, make sure it is something you want to do. I've seen people get cold feet at the 11th hour and second guess themselves. Make sure it is something you want to do.
Is that kind of going back to your other point, saying that they've built this baby, right? Mm-hmm. And it's hard for them to either give it up or the thought of working for somebody else?
Very much so. And oftentimes, if you're a very integral part in your business, a buyer will say, hey, will you stay on for 6 months 1 year, 3 years, 5 years.
Sounds like that would be pretty common from a transition standpoint.
Very much so, very much so. And you'll often see times where sellers say, I'm done. I've given everything I can give. I'm ready to walk away. And so that's a consideration to
Probably the valuation, right?
more or less ongoing, if you want to keep getting a paycheck. But two, you'll have to remember you're no longer the boss. So everything that you've done in the past, it may not be run that way anymore. And most oftentimes buyers will give deference to the people who stay on, to former sellers, and say, how do we need to do this? How did you do this in the past? Sometimes they don't. And that kind of is in the private equity realm, that's very high when they say, we want you to stay on, but things may be different. They tend to swing a big stick. But on a purchasing side, same question. Make sure this is something you want to do, and make sure you have access to all information before saying, hey, this is a good investment. And so oftentimes, typically how a deal will go, well, you'll solicit interest, or you'll say, hey, I want to buy your company, or somebody come to you and say, are you thinking about selling? When you get kind of the high level terms out, you'll sign what is called an LOI, or a letter of intent. And that may have 10 provisions on a 2-page contract to say, hey, here's the purchase price, here's the buyer, here's the seller. Once we sign this, you get 60 days, 120 days to look at all the diligence. You can walk around our facilities. You can, inspect what you need to inspect. It's going to be exclusive. It's just going to be you and me. You're not going to shop this around for 60 days. During that period, that's the very critical period. If you're still a little unsure if this is something that it may be too good to be true, or maybe it's just not quite what I thought it was, at the end, let it lapse and walk away. Don't feel like you'd be tied to being forced to buy a business or being forced to sell.
Look at that as your investment of time to either make a great decision or walk away from what might be your biggest frustration.
Sure. Very much so.
So, I read an article recently, and they talked about there's this silver tsunami coming, right? And I guess for our listeners, the article, how it referenced that phrase was the generation kind of ahead of Taylor and I. A lot of them are business owners, and at a phase in life that they might start selling their businesses. So maybe last question to you, Taylor, is there any trends that you've seen over this last decade, especially in today's age, that are changing the M&A landscape that listeners should know about?
I think there are kind of two talking points on that. Me personally, I've seen a rise in private equity buying into smaller businesses. And based on your valuation and your opinion of what a small business is, they're even starting to hit home here more often than I saw earlier on in my career, which may go hand in hand with your silver tsunami. If it's a very profitable industry, you may see more and more private equity entrants into these smaller markets. We're not a Dallas, we're not a Miami, we're not a Chicago. So I would expect to see that a little bit more if there is such low-hanging fruit and the opportunity is good. And another interesting trend I've started to notice, and not necessarily just in my field, but the introduction to AI, and not necessarily using it as an attorney, but seeing how it affects people's businesses and how more efficient they've become and creating value in that. And a lot of people are developing more into an intellectual property side where you've created something that is valuable that people want to buy, whether it be your software, whether it be your, service, whether it be something you've trademarked or patented or something of that nature. Seen a lot more flow with technology, and everybody's benefiting from more technology. I mean, we've got AI and smartphones and tablets and all sorts.
We carry every answer we could ask with us in our pockets.
Right. And so seeing that affect businesses is interesting, because the people who are selling the businesses and selling the businesses faster tend to have a higher use in technology.
Interesting. So for all business owners, it always feels like we have to continually be on the cutting edge of technology and adoption. And that's a good point is if you're thinking about selling your business, that might be something where if you haven't fully adopted technology or maybe AI, at least look into it. But Taylor, we really appreciate you coming on the podcast, and obviously you and the Friday Firm do incredible work, so we're very thankful to have you.
Thankful to be here, man. Appreciate you.
All opinions expressed on the podcast by the host and guests are solely their own opinions and do not reflect the opinion of Olympus Wealth Strategies or Uptick Partners, a registered investment advisor. This podcast is for educational purposes only and is not legal advice and should not be relied upon as a basis for any decisions. The investments discussed on this podcast may not be suitable for all investors and involve risks that should be carefully considered. Listeners are encouraged to consult with a qualified financial advisor before making any investment decisions. Certain investments may require specific investor qualifications, which not all individuals may meet. Any funds or companies discussed are not a recommendation or endorsement. Guests in the podcast might be actual clients, but are not compensated to be on the show, and their experiences are not representative of all relationships, which might differ substantially.